সরাসরি লোকসভায় নজর রাখবো, বক্তব্য রাখছেন কল্যাণ বন্দ্যোপাধ্যায়।
It was a long back, it's a big village. In the big village there are so many Muslims are there. One Hindu dedicated his property for offer their namaz, and that is the property, that is the mosque is in front of the parliament. In the front of the parliament. Who has not come here? All Abdul Kalam Azad, so all important political leaders, including Bhutto, and the Imam of that is sitting here as one of our colleague, member of parliament. If prayers are offered once in a mosque, it is sufficient to constitute a good dedication. Dedication has been clearly said. Paragraph 39 of the judgment, that the founder must declare his intention to dedicate a property for the purpose of mosque. No particular form of declaration is necessary. The declaration can be presumed from the conduct of the founder, either express or implied. If this is the principle of law, is long-standing in our country, how can you say today you have to register Waqf by user? You have to give a declaration. I don't need to. Therefore, you are trying to, by this bill, you are trying to take away the basic reason of all the judgments of the Supreme Court. This is not correct and this is bad. Madam, neither a document nor express words are essential for dedication of religious or public purpose in our country. Such dedication may be implied for user, permitted for public and religious purposes for sufficient length of time. The conduct of those properties is presumed to be dedicated for religious. It has been said by C. B.K. Mukherjee on Hindu law. C. B.K. Mukherjee on Hindu law of religious and charitable. I do not think that anyone in India is here now. Today in India there is anyone who understands Hindu law better than the B.K. Mukherjee. No one. He has said so in his book. Anyway, new concepts, smart mans have come like a smartphone. Therefore, everything is being done. In the case of M. Siddiqui, through Elas versus Mahanath Suresh Das, 2021 SCC page 1, it has expressly said Waqf by user. Our jurisprudence recognizes the principles of Waqf by user, even absent an express deed of dedication. This is being taken away. Now, long judgment I will not read. This is being taken away by this. Therefore, it hits the basic things. Clause 3, subclause 5 of the said proposed bill, the verbal declaration of Waqf has been taken away. This is contrary to the history of creating Waqf by any individual. Several properties are dedicated as Waqf by a good number of persons to be made as Waqf property. Madam, the deletion of the word either verbally or violates the right of the Muslim as protected under Article 25 and 26 of the Constitution. Therefore, it hits the basic structure of the Constitution. In Commissioner of Police versus Acharya Jagadish and the Abbuddhota 2004-12 SCC 770, it comes from our state. When CPM was in a power, they killed Ananda Margis. In that case, this judgment has come. The protection guaranteed under Article 25 and 26 of the Constitution is not confined to matters of doctrine of belief, but extends to act done in purpose of religion, and therefore contains a guarantee for rituals, observances, ceremonies, and mode of worship which are essential or integral part of religion. What is Waqf then? It's an integral part of the religion. Madam, essential part of religion means the core beliefs upon which a religion is founded. Core belief of the Muslim is that Allah is there. I am dedicated my property to the Allah. Therefore, it's a Waqf property. It is upon the consensus essential power practice that the superstructure of religion is built, without which religion will be no religion. Madam, nobody can say that essential part or practice of one's religion has changed from a particular date or by an event. The proposed amendment clause 3 proceeds with the assumption that Waqf are riddled with the issues of mismanagement. It appears that primary basis of the assumption, very important, the very primary basis of the assumption is the quantum of pending litigation surrounding Waqf, if the basis of identifying body as mismanaged in the amount of litigation that is pending against in this cannot be a rational basis of determining the standard of management of body. In fact, the Honorable High Court of Delhi in the case of Union of India, Kiran Manua, they has given the details of the pending cases. If pending cases are the ground for bringing the legislation, now I tell you the figures, statistics. In the pending civil cases in Supreme Court, 64,687. Pending criminal cases in Supreme Court, 18,235. Total pending cases, 82,922. And in Waqf, all over India, 14 to 15,000 cases are pending. If it cannot be said to be a basis. Madam, Section 3A, the creation of Clause 4, Section 3B, insertion of section that mandates that every Waqf, prior to the commencement of the shall file the details of the Waqf property dedicated to Waqf. I have already dealt with that.
Banglar Awaj, Bengali Breaking Stories, Zee 24 ঘন্টা।